Hey guys, that title wasn't clickbait. The Department of Justice just came out and said we can open carry long guns such as rifles and shotguns without being prosecuted in the streets of DC. Recently, the Department of Justice has been doing some anti-gun things, but this seems like a positive step forward. Or is it? It kind of feels like a trap, guys. I don't know about you, but I don't want to be the first guy to try this with all the National Guard around, and I don't know that they've been updated on this. Plus, it hasn't mentioned at all what DC's mayor thinks of this or the city laws of DC have to say about it, any of the codes. So I would be very careful if you plan on doing this. And by the way, guys, in order for this to apply to you, you need to be a resident of Washington, D.C. But this is what the Second Amendment is about, and I'm sure a lot of you are against open carry. You've got some good arguments that it could make you potentially a target, it advertises you're carrying a gun, or someone may take that gun from you because they see it. But here's my issue. America is about freedom, not safety, liberty, not security. Open carry, concealed carry, either way, it shouldn't need a permit. It should be considered constitutional carry both ways, and we shouldn't need anyone's permission to do it. And if you guys agree, why don't you comment "Free men don't ask permission" down below and give this video a like if you're enjoying it so far. And now a very exciting step for the state of Illinois and its assault weapons bans. Some of you may not have known that it also has counties banning assault weapons. Yeah, guys, Illinois is that messed up. So, this is Benitez versus Cook County, and writ of certiorari has been filed for the Supreme Court to get involved. That way, this can go before the Supreme Court. And then it won't affect all 50 states because it's not a federal law, it's not a federal case, but it will affect the rest of the state of Illinois. That's a big win, guys, especially for those of you living in Chicago. I know I have a lot of viewers there. This case was first heard all the way back in March 2024, and then it was heard again in July of 2024, and both times the courts upheld the ban by the county. Very disappointing, guys. That is not how you're supposed to rule on it after New York versus Bruin, where you're supposed to apply text, history, and tradition. But the state of Illinois considers assault weapons to be military-style weapons. Now, my response to that is that, yes, of course, the Second Amendment protects military-style weapons. There wouldn't be any point in the Second Amendment if it didn't. But the state of Illinois doesn't agree, and they say that you do not have a Second Amendment right to anything military-style. And I would just like to add that about 24%, 25% of gun sales in this country are AR-15s, not to mention all the other styles of semi-automatic rifles. This is the most commonly owned rifle in the USA. Under Heller, the AR-15 should be protected because it's not unusual. Now, the Heller decision says you have to apply, is it dangerous and is it unusual, and it has to be both to apply. Well, all weapons are dangerous, so that's not really something to apply in the case at all. Considering the only thing that outsells the AR-15 is typically a Glock 9mm, guys, the Supreme Court needs to step in now. This is affecting a lot of parts of the country, but let's just get a win for Illinois right now. Those guys really need it. And now we've got another huge win out of the state of Delaware. They just restored the gun rights of 18, 19, and 20-year-olds who had recently been deprived of their handgun rights. Now, why did Delaware do this? Because they have anti-gun people in charge. Back in 1987, the district court, along with everyone else, agreed that they needed to reinforce the Second Amendment part of the Delaware Constitution. So this law should have never happened. And personally, I feel that young people should be carrying handguns. They're more likely to live somewhere a little bit more rough because they haven't earned enough money yet to move out of a bad neighborhood. They're more likely to be working late at night. They're more likely to be robbed, working at a gas station, or working a register. I want to see young people understanding gun safety, getting gun training, and carrying so that they stay safe and they keep the people around them safe. You know, a lot of these mass shootings that happen tend to happen to young people. And I think if more people were carrying a gun, they could put that bad guy in the ground instead of being a victim. So I'm happy to tell you that the state of Delaware ruled that this is unconstitutional and unenforceable from here on out. Congratulations, guys, those of you that live in Delaware. Let me know with a comment down below if you live in Delaware and if you were affected by this or anyone you know was affected by this. And now let's talk about the Massachusetts handgun roster. Now, I told you about this the other day, that it was ruled on in a negative way, The law was upheld on August 29th, but we have the FPC coming in for an appeal, so guys, there's still a chance. The Massachusetts Attorney General and the Secretary of Public Health are the reason FFLs in Massachusetts cannot sell you a gun or you cannot purchase a gun unless it meets the requirements of the Massachusetts rosters. And as a Californian, I can feel your pain. Massachusetts laws on the rosters are very similar to California's. Let's say that either one of us living in the other state wanted to buy a new Glock. We could go out in any other state, look at any new model of Glock, and purchase it. In states with a roster, that's not how it works. Currently, we can only have Gen 1 through 3 Glocks in California, and I think it's the same in Massachusetts. I'm not sure on that. But that's how these handgun rosters work. And in order for a gun to be on the roster, it has to meet state safety requirements. They drop test it. They check if it has a loaded chamber indicator. They want an external manual safety. Things like this. Massachusetts, the judge at least, didn't believe that these people were being deprived of their Second Amendment rights because they could still buy guns that were on the roster. And they're actually hoping this ruling will encourage other states to enforce their own handgun rosters. So guys, I would be careful if you live in a state that's free right now. I would maybe take whatever money you have and buy the handguns you want, because you never know when a state is going to adopt these unconstitutional laws. Now, normally I would be telling you that they're ignoring New York versus Bruin. Most of the courts have that are anti-gun. But this time they tried to find a loophole in Bruin. They're saying that because guns had to be tested for safety in the 1800s, that making sure they're safe enough for a roster is completely constitutional and falls under the test of text, history, and tradition that is part of the ruling of New York versus Bruin. So they might have got us there, guys. And I'm sure none of you are surprised to find out that government workers, policemen, members of military are exempt from these rosters and can own whatever they want. What do you think about this? Let me know down below. Do you live in Massachusetts? Are you affected by anything like this? And I saved one of the best cases for last, guys, so I hope you stuck around to see all these stories. 25 states, along with Pam Bondi's DOJ and President Donald Trump, are filing against the state of Hawaii for their refusal to issue concealed carry weapons permits, their large capacity magazine bans, and their assault weapon bans, meaning that the Supreme Court will likely take these on, rule on them, and these rulings will affect the entire nation. This might be one of the biggest wins we've ever had, and I'm going to love this current administration in the Department of Justice if they get that done. Because Hawaii falls under the same Ninth Circuit that California does, and every time citizens try to fight these laws, the Ninth Circuit decides, no, you don't get a Second Amendment right. So I am very excited about this case. I'm excited that Trump and Bondi have filed this amicus brief along with 25 other states. Normally, the Supreme Court will not get involved with a case until it's made its way there in a natural way. They want it to go through the full system and be ruled on by all the courts before they hear it. But with the President and the Department of Justice and exactly half the states wanting the Supreme Court to step in, I think they're going to have to actually step in and do something about this, guys. What do you think about this? Let me know down below. If you like my content, make sure you're following me on YouTube and Instagram. And I'm glad you watched my long-form content as well as my short. Thank you guys for being fans, and have a great evening.